Good morning and welcome to our second edition of Opportunity and Change. My name is Bill Bynan and I'll be your host today. I hope you had an opportunity to join us for the last session. Wanted to let everyone know that we will be providing the recorded slides shortly after next week's last presentation so that you can have those either to print or to watch the presentation again. As you logged in this morning, you see the disclaimer. Basically, the disclaimer says that you agree not to share or reproduce the information we're going to share with you today. So thank you for that. Again, my name is Bill Bynan. I'm the CEO of Capital Wealth Advisors. I've been doing this type of work for over 25 years. I'm proud to lead a team now of about 50 professionals in the area of wealth management and planning here at our firm, headquartered in Naples, Florida. We have offices in North Carolina, advisors in Omaha, Nebraska, albeit they're a little cold and snowy out there, so you want to avoid Omaha at the moment. No offense to any of you in Omaha, as well as throughout the Southeast, working with individual families. So we're happy to have you today in this sort of interesting time that we have around planning. Firm background, as I said, we've got about 50 people on the team. This is a little bit outdated, but we're approaching about 1.9 billion of assets. What we do is we work with individual families around the country and their estate planning, their financial planning, their wealth management, and as well as providing access to our market research and our wealth advisory business and our family office services. So today is part two of a three-part series. Last week we talked a lot about the impending tax changes and how those were going to affect our estate plan. I'll give you a recap of that here in a moment. Today we're going to focus on something that really changed during the last administration, and that's really planning around IRAs, IRA distributions, and qualified plans. We'll talk about the Secure Act, which was passed in 2018 or enacted in 2018, and how that really is going to affect you, both from an income but also an estate distribution perspective as well. And next week we'll be wrapping up our series. We're going to spend we're going to really dive deep into looking at estate planning in a different way, focusing on liquidity in the new potential tax regime, and then identifying opportunities for additional planning that may help you minimize the sort of impact of estate and gift taxes on your family. So hopefully you'll be able to join us next week, Wednesday as well. So from a part one recap, it's kind of key takeaways. Again, we're facing a new tax regime potentially that is proposed by the Biden administration. As a result of that change to income and estate taxes, we really think it's important for you to review your existing plans, look at your documents, really do a financial analysis of your estate to see where you fall with regard to that tax impact. That estate analysis is something that should be repeated every year or two to make sure that you have a handle on your assets, not just from a size and tax perspective, but also really from a liquidity perspective, because with the potential of lowered unified credits, which is the tax-free amount you can transfer at your death, combined with potentially increased tax rates, that liquidity analysis is very, very important. We're going to cover next week, we're going to dig into alternative gifting strategies to help us capture that unified credit. And if you have existing plans, whether they be revocable trusts or irrevocable trust or insurance plans, it's a good time to review those as well. And that's the key takeaway from last week. And again, next week, we're going to dive again a little deeper into that area. So today on our agenda, we're going to talk about the Secure Act, which I mentioned. The Secure Act provided some fundamental changes to IRA planning and IRA distributions and how they affect families. With the impending tax changes, we're going to consider the use of a Roth IRA, really understanding how that works and what the impacts could be economically on families and when you should consider that and how you really evaluate that. We're going to talk about a new strategy that we've been working on for quite a while, really for the last year and a half, called Ira Maximization. And this is really for families that have retirement plan assets, but don't need them in their daily sort of income planning and want to utilize those assets and maximize the values to their families. And then we'll review key takeaways today. So hopefully you find it useful for you. Very topical. Last week we talked about the pending tax changes and what was had been talked about in the campaign. And we speculated that it was going to be something that the Biden administration would tackle after the stimulus. And interestingly enough, in the last 24 to 48 hours, there's been lots of news about President Biden talking about his next agenda item, which is the tax aspect. So some of it was pretty predictable, really outlining what we talked about last week, the fundamental changes to income and estate tax that he had put in writing in the campaign. He's sort of reiterating that. One plus or sort of positive outcome of the communication this week is it looks like that the administration is not going to make the traditional push for the tax changes to be retroactively applied to January 1 of 2021. Historically, in tax changes, they've tried to bring them back to the beginning of the year in which they're passed, make them retroactive, which is why we had such a drive to plan and make gifts last year toward the end of the year. The administration sees its challenges in sort of the tightness of the margins between the parties. So they're really looking at having this applied, at least in their recent communication, to 2022. That will really open up the doors for all of us to have an opportunity if we didn't get all the planning done last year, or we didn't take the opportunity to make gifts, to really have a little more time in this year to do that. And we'll talk a little about today and also next week. So very topical in the news. Keep your eyes out for future communication. But as it stands, it looks like we're going to see the sort of the tax proposals coming out in the very near term. And you're already starting to see some work from a Democratic perspective to change the filibuster rules. These are in preparation of really a tough negotiation, tough fight in Congress and the Senate, and the House and the Senate around these proposed tax changes. But they are likely. We'll keep you abreast of them along the way. So let's talk about the Secure Act. So the Secure Act was passed and put into effect in 2018. And the two major takeaways, I'm going to go through all of the sort of aspects to the two major takeaways for me were really around required minimum distributions that you have to take from your IRAs, and also the elimination of the Stretch Ira, which we'll talk about. In the Secure Act, it repealed the maximum age for contributions to an IRA. So prior to the Secure Act, once you hit the RMD age, or the time to take your distributions, which at the time was age 70 and a half, you couldn't continue to contribute. So they've taken that cap off of that. It increased the required minimum distribution age, or RMD, from 70 and a half to age 72. So if you hadn't already begun to take your distributions, you could delay those to age 72, which was a benefit for many families that didn't need the income. Really helped from an income tax perspective. It also really tried to drive additional savings. So it allowed long-term part-time workers to participate in 401k plans, which was new. It offered more options for investment strategies inside the 401ks. It also permitted parents to withdraw $5,000 from their retirement accounts penalty-free when they either had a new child or adopted a new child for the payment of qualified expenses. And it allowed $10,000 withdrawals for parents to repay student loans out of 529 plans, which was a shift from that perspective. So the other key takeaway was that to pay for the things that I just talked about, they eliminated what we refer to as the Stretch IRA. So the Stretch IRA gave us the ability, if my father were to pass away and leave me his IRA as a beneficiary, it enabled me to accept that IRA as a beneficiary IRA and then recalculate those required minimum distributions over my life expectancy. So it allowed me to really stretch out those distributions over my lifetime, minimizing the annual tax impact because I could take it out in smaller bites over my lifetime. So in order to get some of the benefits that they provide in the Secure Act, they took away that. So under the current rules, in Secure Act 1, we have a situation where if that same scenario applies, where my father leaves me his IRA, if he leaves it to me as an individual, I have to withdraw or exhaust the entire account through distributions over a 10-year period maximum. So I have to take all of the assets out of that IRA as distributions over 10 years. So the impacts of that are that it potentially could put me in a higher tax bracket, and it forces out taxable income to me over that period of time. Many families that we work with worry or have concerns about their children or grandchildren receiving money outright. So in many cases, they would have created a beneficiary plan where their IRAs would flow to trusts for the benefit of their children or grandchildren. Under the old rules, the trust could, in essence, use the measuring lives of the beneficiaries to have that stretch within the trust, and it could distribute those out to the families. It's called a conduit trust, and had the language, and if the language in the trust, they could do that. Under the current rule, if it's a non-human beneficiary, the trust will have to take the distributions of the entire IRA out over 5 years. So if you have, this is a very important key piece to remember for today. If you have your trust as a beneficiary of your IRA, it is very important to review that document, because under the current rule, if you have a conduit and your purpose of running it through the trust was to hold the assets long-term in trust for the family with income going out, under the current rule, each one of those 5 payments, large payments coming out as distributions, would then be shipped out to the beneficiaries. And many times it's an unintended consequence to the application of the new rules to your current plan. So very important to review your IRA beneficiaries. So that's Secure Act 1. Just as a reminder, if you have any questions, feel free to put those into your question section on the Zoom app. I have Daniel London with me today, one of my colleagues and advisor in our firm. He's going to help manage the questions along the way so we don't miss any of those. If we happen not to get to your question, I will be answering them directly offline, or we'll set up a time that we can answer them over a call or a meeting for you. So again, if you have questions, today's designed to be interactive. If you have them, please feel free to send those on to Daniel. So with everything that's good, there's always an area for improvement. So we have a proposal on the table in the Congress right now for Secure Act 2.0. And it really just tweaks and takes some aspects of the original change a little further. The biggest of which is to take the required minimum distribution age from 72 to 75. As people are living longer, that's been a push by many people in Congress to do so. So if you are not of age 72 as of yet, it will allow you to push it out to your age 75 for your distribution. If you have already begun your distributions because of your age, let's say you're already 72 and you took your first distribution last year, then you would not qualify for the deferral to age 75. So it's, if you haven't begun your distributions, then you can push it out to the age of 75. Also, historically, if we didn't satisfy our requirement in distribution, the penalty was substantial. So if you happen to miss a distribution that was required after the age of 70, 70 and a half, and now 72, the penalty was 50% of the value of that distribution. So a very hefty penalty. Under Secure Act 2.0, the proposal would reduce that penalty from 50% to 25%. And then if there would be a potential that you could have that lowered to 10% if it was dealt with in a very timely fashion. So again, trying to reduce the penalty aspect to those missed distributions would be beneficial if you happen to make a mistake. We take it very seriously. We have it in our system for every one of our clients to make sure that we are tracking that as a backup for all the families to make sure that we have them. So again, important to take those distributions when required, avoid the large penalties. The other aspect is allowed individuals with retirement accounts under $100,000 would not be required to take that requirement distribution. So eliminated that for small accounts. It also increased the catch-up provision, allowing a contribution limits, increasing them to $10,000 for 401ks, 403bs, and $5,000 for simple plan participants, and for those 60 plus. So they moved that from 3,000 up from 6,500 and 3,000 to 10,000 and 5,000. So again, from a catch-up provision to get more money in your IRA, good opportunity for you. Many of you likely would use your requirement distributions to make qualified charitable donations. So under the current rules, you can use up to $100,000 of your RMD, and you can provide that as a direct gift to a qualifying charity. And if you do that, it does not become part of your income. Under the current plan, those distributions are only available out of an IRA, not out of a 401k or another type of qualified plan. The new proposed rule would allow you to give up to $130,000 up from $100,000, and it will also allow you to extend those opportunities to all types of retirement accounts. So very important if you're using some of those monies to fund your charitable initiatives. You have if this goes through this year as expected, we'll have an increase to that. And it will also allow for distributions to gift annuities and other charitable opportunities, remainder trusts, things that were restricted under the old rules. They're loosening the flexibility to try to drive more money to charity, which we think is a positive. Not going to go through a lot of these in detail. Big picture is increasing auto enrollments, company contributions, so really driving savings, kind of forced enrollment for people into retirement plans. What they're trying to solve in this change is trying to solve the lack of participation that many companies have with their employees participating. So it auto enroll them at a 3% contribution rate and then increase that over time automatically. So kind of encouraging through regulation for savings for retirement plan participants. So we have in today's world, we have traditional and Roth IRAs. And the Roth IRA, either at the beginning or inception, you can fund with after-tax dollars, where a traditional IRA is funded with pre-tax dollars. So if you think about it, if I have pre-tax dollars in an IRA, they're going to tax them when I pull them out. If I funded them after tax, I'm going to be able to pull those out tax-free. So when we think about that, they both have tax deferral on the growth, but the IRA that is a traditional IRA is going to be subject to ordinary income tax, where the Roth IRA is not going to be taxed on the distributions, being that it was funded with after-tax dollars. So when we think about this from a perspective of an opportunity, we also have the ability to convert an IRA from a traditional to a Roth. In order to do that, we have to pay the tax. So I'm going to take you through an analysis of how we consider that, how we look at it, and really want to understand whether it's a good idea or a bad idea. I would say in my career, for me, the primary question has always been, does the client feel that income taxes are likely to be higher in the future than they are today? And that was always sort of the number one qualifying question that we had. And I think today we can say that with more certainty than we have been able to say in a number of years. If we had a view that taxes were going to go down, my opinion was a Roth was not as beneficial. But now that we have sort of a path in front of us with higher taxes, Roth conversion should be considered as an option in your planning. And Daniel, I see a couple questions that have popped in.
We have a great question from Frederick. So for a married couple, if each partner has a traditional IRA as well as a SEP IRA, would you suggest changing the beneficiary of those accounts to the trust that will ultimately be created if one partner's passing?
Frederick, thank you for the question. It would be dependent on who the ultimate beneficiaries are and how your feeling is. So from a spousal perspective, you can leave to each other with no issue, and it would really be the contingent beneficiaries. And if you have a concern about the money going directly to those other beneficiaries, then the answer is a trust is a benefit. If not, you may want to consider leaving it outright, because that does stretch out the distribution. but happy to dig into that a little more in detail if you like. Really some detailed questions around the beneficiaries will help us come to that answer.
We have another great question that asks specifically about a certain kind of trust. If a gentleman has an IRA account, the beneficiary is a special needs trust for a special needs grandson, would the 10-year rule still apply to that type of trust?
There is an exception for beneficiaries that have special needs and disabilities. I would still recommend having, depending if I'm assuming the trust was created prior to the law change, I would still have it reviewed just to make sure, because we have that exception, I still want to make sure that that conduit provision doesn't force it out of the special needs. Probably doesn't, but it'd be a good idea to take a look at that. Okay, thanks, Daniel. And thank you for your questions. So when we think about a Roth conversion, we have the ability to make a conversion to pay the tax and then have that asset grow tax deferred and then come out on a tax-free basis. And we'll walk through a couple of case studies to see whether that makes sense and sort of how we look at those. So first case study we're going to talk about is we have a husband and wife. They're 64 blended age. They have an estate of 25 million. The husband has an IRA from a 401k rollover that was 1.2 million. They're invested conservatively. He has a low risk tolerance, so his expectation is a 5% gross annual return. And the family has unified credit available. Also in this example, my understanding for this client, this is a real client, the family didn't have the need for the IRA to fund their lifestyle. So have the IRA, it is an investment asset, they're growing, but their plan was just to take the required minimum distributions. So the first question is should we consider a Roth for this? And there are really things to think about. So when you think about a Roth IRA, there are two options to how you fund the tax. The first is you take the money from the IRA to fund the tax, which in my opinion is a less efficient way, and I think our math will walk you through why. The second idea would be, or option would be, to pay the tax from an asset outside of the IRA so that the full IRA is tax-free. So those are the two typical ways that it's done. I think as we go through this, it'll be clear which one is a better option if available to you. So what we've done in this idea is we have taken the idea of the traditional IRA. We're growing this at 5% each year. You will note that we're only taking the requirement distribution at age 72, and obviously if the law changes, we'll do that to 75. We take the IRA value. We have the end of the year requirement distributions. And remember, we assume that this family does not need the distributions to fund their lifestyle. So we're going to show the value of those reinvested so that they're not spending it, so we can look at it side by side. We have estate and income tax and the net to the family. And this gives us an IRR on the net to the heirs. On the right side, we look at a Roth conversion. In this example, we're using a Roth conversion where we are funding the tax payment out of the IRA. So you'll note you see a valuation drop in year 2 because I'm pulling out the money to pay the income tax in year 1. We take the IRA value, we grow it, we look at the value estimated at the second death and what the net to the heirs are going to be. So when you actually look at it as we go down through the process, there's not a dramatic difference in the comparison. What would accentuate it is if we had a higher income tax projected over the years, the Roth would do better. But if I look at it statically, let's say that the tax change doesn't happen, the reality is it's very similar, paying the tax over time through distributions and reinvesting those or doing the other. Obviously, if income taxes go up, you're going to see a larger benefit for the Roth. Okay. So again, taking it from internal assets, probably not a good idea from my view. And I think you'll note the difference when we look at this from a perspective of using outside assets. So if we have external assets to fund the IRA tax, key piece over here, I'm getting the 480 from another bucket. I'm getting it from somewhere else. I have cash, I have other investments that I can cash out, and I'm going to keep the IRA intact as a Roth, it changes over time the benefit in favor of the Roth. It's just a better return because, again, I'm not pulling money out of the Roth in order to get that tax payment. So as we look at it, it is a substantially better opportunity. If you were considering a Roth, our recommendation would be to fund the tax from assets outside. So once the Roth is converted, remember, we have tax-free distributions for your life, and the beneficiaries can access that money tax-free for their lives. It does not eliminate the inclusion of the value for estate taxes, but it really helps us from an income tax perspective. Okay.
We have a question from Robert. This question is regarding the COVID exemption that occurred in 2020 on IRA distributions. Could you clarify what that exemption was?
Yep. So if you were at the age of a required minimum distribution age, they suspended the distributions due to COVID last year. So you did not have to take the distribution, and there was no penalty applied for not taking that distribution. So if you didn't need the capital, you were able to, in essence, defer that, leave it in, let it grow. There haven't been any discussions about that for this year, but we'll keep an eye out, and you should keep an eye out to see if they're going to make that change. My guess is they won't suspend them for a second year, but it's politics. You never know where that comes out.
Then we have another question pertaining to this specific slide. Frederick would like to know, how much can you convert in 1 year?
You can convert, I believe, and I've double checked, I think the cap's off, and you can convert the entire amount in this year. I don't think there's a cap on the total, as long as you can pay the tax. And Frederick, I'll triple check that, and we'll email you just a confirmation to make sure that I'm correct on that. I'm pretty certain that's the case. Thank you for your questions. So I think it's important to think about other alternatives. So as we talked about, many of our families have the IRA, they're not using it to fund their living. We now have a distribution schedule that's very different than it was a couple of years ago, kind of forcing those out with the potential of higher estate taxes and higher income taxes. The net asset to the heirs becomes less beneficial over time. So many of our families have tasked us with the thought process to say, what can I do to maximize this asset? Is there anything I can do to minimize tax or to lock in my tax today? Is there anything I can do to help get these assets in a different way to trust for my children or my grandchildren? And what are the best ways to do that? So we took an old idea and kind of tweaked it a little bit, and we call it Ira Maximization strategy. It's really leveraging the Roth conversion idea. So I first start with the families to say, are you willing to pay the tax? So if you're willing to pay the tax to convert it to a Roth, but you really don't need the money, we should consider this second option as something to consider for the benefit of children or grandchildren. So again, from a family perspective, the typical family that looks at this is a family that believes that they don't need the IRA. They believe that taxes are going to be increased, and they want to maximize the value net of estate tax to the family. And lastly, they'd like to protect the assets in a more traditional estate planning way through asset protection trusts or ongoing generation skipping trusts for their family. So we look at this and we take an IRA and we say, okay, either in a lump sum, and I'll talk through a couple real family examples, or over a period of time, I want to distribute that IRA out and I'm going to pay the income tax. Then what I want to do is I want to gift those assets to an irrevocable trust, and typically a generation skipping exempt irrevocable trust, which means you either use unified credit, hypothetically use your unified credit to gift that. We apply generation skipping exemption to that trust through a filing, and that enables those assets in that trust going forward to be out of the tax system, meaning the assets can go from generation 1 to generation 2 without tax, and from generation 2 and beyond without tax. And so we move those assets via gift into the trust. The first option would be, I have a husband and wife, they're healthy, and they say, okay, we're going to gift the money into the trust, we're going to invest it. So let's say we do it in a lump sum in 1 year. I gift it in the trust, I'm going to invest that money, and then over a period of 7 to 10 years, I'm going to fund a life insurance contract for the benefit of my children and my grandchildren, ensuring both lives, husband and wife, getting the maximum leverage. Option 2 would be, and the real life scenario is where family didn't believe they need the IRA, but one of the spouses, the owner of the IRA spouse, says, well, listen, I really want to make sure that if I were to pass, I'd like my wife to have access to the money, or my husband to have access to the money, just as a safety net. So in that example, we gift the assets into what we call a spousal trust, or a spousal lifetime access trust. We hear them referred to as SLATs for short. In that example, we insured the husband's life, and at his death, there's a tax-free bucket of money that his wife can access for her use in lifetime. And then at her subsequent death, the assets go downstream to the next generation. The other fact pattern that I'm seeing a lot lately is we have families where generation 1's been very successful, and generation 2 has been very successful growing their estates. So many times grandparents will say, listen, my kids have done really, really well. I'd like to really do something for my grandchildren. So in this example, we take that asset and we put it into a trust that's designed not to insure mom and dad, but to insure generation 2 for the benefit of generation 3 and beyond. And it's a much larger leverage that you'll see as we go on. So I've taken each of these 3 scenarios, we'll walk through, and then we'll summarize them on IRA maximization. So again, we have a $1.2 million IRA. Client was considering a Roth conversion. Again, the same math, 480. We saw the math as we went in our early example. And then we said, okay, let's look at maximizing this for future generations. So in this example, they distributed the IRA out over 7 years, paid the tax, and they were able to fund just shy of $4 million death benefit in the trust. So we look at this on a net basis. So if, God forbid, they were to pass away at life expectancy, the comparative is under the Roth conversion plan, the beneficiary received 2.2 million. Under the max plan, they received 4.6 million. So quite a substantial bump in value for the family. If I looked at it where I wanted to provide assets for the surviving spouse first, I'm only insuring one life, which means I can acquire a lower amount of life insurance, but we have it in that spousal trust. And the comparison here is same on the Roth side, 2.2 million versus 3.6. So this 3.6 million, including the death benefit, would have been available if the husband were to have passed away in our example, that the surviving spouse can have access to that during his or her lifetime. And at their subsequent death, that goes tax-free to the kids. So this shows at the end of the day, both spouses are gone, 3.6 versus 2.2. Again, a pretty substantial change. One of the other things to keep in mind is in this example of the Roth, on the Roth conversion, these assets are going to be given outright, if you will. They're going to be distributed as outright via the IRA. When we look over here, this allows us to keep it an ongoing trust for the benefit of your heirs, protecting them from divorcing spouses, creditors, other claims that they may have against them. So those assets can be protected. So the secondary benefit is really the protection of the asset on top of the leverage and value. If I have this situation, if you remember, where we had a wealthy generation 1, a wealthy generation 2, and we said, hey, we want to really provide benefit for future generations by insuring generation 2, the benefit is substantial. And we take this out to a very long life expectancy of the second generation. We grow, the Roth grows to about 7.2 net after the estate taxes to the family, where we're able to get 23 million to the grandchildren and great grandchildren in this example. So again, in trust, protected, but we've taken an IRA that was going to be worth after tax much less and leverage that out. So if you have a situation where you don't need the IRA, there are options to leverage this and provide additional protections on a tax-free basis to the family. And this money here is tax-free as a benefit inside the trust. So to summarize, I'll throw these all out here. So in the current IRA plan, at life expectancy, they'd receive about 2.2 million. If I looked at the joint life expectancy, that number jumps to a potential 4.6 million. That's a 107% increase of benefits, so not so bad. If I do the net with the spousal access in between, I'm still getting a 65% increase, taking that to 3.6. And if I'm really looking for to leverage assets for future generations, ensuring the younger members of the family, we're able to increase that by roughly 10x, so 933% over lifetime, so 23 million. So you can see that the gamut of options that are there, and it's important to consider if you don't have a use for your IRA for your personal income needs, this is a great way to really leverage that asset downstream to the family. So today, and I'm sorry we've run over a few minutes, but the key takeaways are, first and foremost, review your IRA beneficiaries. Make sure if you have a trust as your IRA beneficiary that we are really digging into the trust language to make sure it still works under the current Secure Act rules that changed. If you have a belief that income taxes, as I do, are going up, you should consider a Roth conversion. Whether this could benefit you and your future generations, if you need it for income, really could benefit you. But if you're going to make that conversion, our recommendation would be to use outside assets to fund the tax obligation.
We have another great question.
Sure.
So we had an attendee ask, what estate planning resources does CWA offer to clients that do not reside in the Naples area? And the second part of that question is, are there additional fees charged for an estate analysis?
Yeah, so I answer this latter part first. For our clients, we do not charge for the estate planning aspect of what we do. We have a sort of singular advisory relationship, and all of that is included. I'm happy to say we have clients all over the country. I think last we checked, we have clients that touch over 30 or 40 states. And the federal tax law is applied identically regardless of your state residence. Many states have secondary tax situations from inheritance and gift and estate that we would look at and do, but we do planning across the country and have been doing it for over 25 years. So certainly have an opportunity to hopefully add value to you there. Happy to have a conversation about that. So from another key takeaway is we want to make sure that we're analyzing our IRA from an income need perspective. So before you make a decision to use other assets to convert to a Roth, to consider an IRA maximization, the first thing is to rule in or rule out how much, if any, you need of the IRA. One of the things I don't think I made clear, as it just popped in my head, is you can also, this is not an all or nothing. You can take part of your IRA and enact these plans. You can do a partial Roth conversion. You can do a partial IRA maximization. So it isn't something that you have to consider. It's not an all or nothing situation. So as we go through the process, the first thing we do is we look at the financial analysis and income need to make sure that you don't need all or part of the IRA. And I think that's important to give you comfort before you even make any traditional gifting or do things. We want to make sure that you feel comfortable that your lifestyle will not be affected. It's your money, you worked really hard for it, although we love our children and grandchildren, but we want to make sure that it still fits within your personal planning, your personal needs. And lastly, I would say, if you don't need it, if we go through that process, certainly considering an IRA maximization could add, lots of economic benefit to families in multiple generations. So if that is your family situation, I would highly recommend looking at it, analyzing it to see if it fits for your family plan. So with that said, we can take any additional questions, Daniel, if we have them. I know we're running over by about 10 minutes.
It's like your fourth grade teacher used to say, if you have a question, there's probably other children in the group that have the same one.
Yeah. So with that said, if you have additional questions, feel free to email us. We're happy to answer them if you want to set up a time to talk. happy to do that as well. Luckily, last week we had a number of questions that came in after the fact and had a couple of phone calls and conversations. If you're in the Naples area and you'd like to meet, feel free to reach out to schedule. If you're not in the Naples area, we can do a Zoom meeting anytime you like and walk you through your personal situation. I appreciate you taking part of your day today to learn a little bit about IRA planning. Don't forget to join us next Wednesday, where we're going to wrap up the 3-part series. We're going to talk about liquidity and tax, how that's affected by the current proposed changes to the tax regime. And then we're going to identify and evaluate several gifting strategies that may help us minimize the impact of that estate tax change. So I hope you found today interesting. We appreciate your time as always, and have a wonderful day.
Thank you all.